Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about the role of a power of attorney. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, so power of attorney. People are generally understand how effective and helpful a power of attorney can be, and are also freaked out about it at the same time. In a nutshell, at a very high level, what the person that is named the power of attorney has the ability to do is sort of anything that they need to with regard to your life, particularly when it comes to finances and sort of like life choices around money, okay? They can sign checks for you. They can often invest money for you. They can often sell real estate for you. They can do all of these different things. What makes people nervous about the power of attorney, no matter who they are appointing to that position, is that typically when you create a power of attorney, you create it in a manner that is called a durable power of attorney. What that means is the moment you sign that document and name someone to be your agent, which is what that's called when you name someone to be the power of attorney, that power goes into effect immediately. It doesn't come into play later, like if you were incapacitated or something like that. That's called a springing power of attorney. It comes into play immediately. There's a reason for that, and the main reason is that it's very difficult to get the confirmation that you need from a doctor or from a medical professional to say that you lack the capacity to make decisions, okay? The reason it's hard is because doctors don't want to get sued if they make the wrong choice. So they err on the side of caution that you have the capacity to do these type of things. And what it can end up happening is you can find yourself in a difficult spot because you don't have what you need for the power of attorney to come into play. So I highly recommend and pretty much only do durable powers of attorney for my clients. But there is that fear that when you grant this power, someone could take advantage of it. And that is 100% possible, okay? I'm not going to sugarcoat it. It is possible that someone could take your power of attorney or use their power of attorney for bad things. There are a couple of ways to avoid that, which I'll talk about real quick, but I really want to talk about what being power of attorney means, okay? So one of the ways that you can limit the power of attorney from exercising their power is to just not provide them with the documentation that they need to prove that they have been named your agent. What I tell a lot of people is after they sign their paperwork, if you don't want to have someone wield this power immediately, just keep your power of attorney under wraps. Tell everybody, hey, I did my estate plan. It's in the office in case something happens to me. But until that time, nobody will touch it. If they don't have the actual power of attorney, then they can't exercise it. They can't present it to a financial institution. They can't present it to anyone. If they can't present it to those people, then it's really as if it doesn't exist out there in the real world. Okay, so that's the easiest thing to do. When it comes to being a financial power of attorney, and this is what I tell clients as well, the person that you name to be your agent, or if you are named to be someone's agent, you have a fiduciary duty to act in their best interest when it comes to their finances. That means you can't buy things for yourself. You can't buy things for your friends and family. You can't move things around unless you have some justification for doing so, and it needs to be good. Here's the other thing to remember. If you are named as someone's agent, and that person actually can function completely and wholly and do whatever they want, you do not have the authority to make decisions that they don't want to have made, okay, quite frankly. Whether you believe they are good decisions or not, you are not in charge of their finances. They are not relinquishing authority to you, okay? They are granting you the ability to supplement the authority that they already have. I've seen this a couple times where people will make choices, they will do things, often it's for elderly people, maybe for parents or something like that, that they think are in their best interest, but are really just against their wishes. Dad wants to sell the house, but you don't think it's a good idea, so you find some way to stop it, or vice versa. You think he should be saving money on taxes. He doesn't care. He doesn't want to get rid of his money. He wants to hold on to it. You do something anyway. Okay, that can kind of get you into trouble potentially. So if you are the power of attorney, remember you have to act in the best interest of your person, your grantor, and if you don't, then it can get you in trouble. Okay, so power of attorney in a nutshell. How to be a good power of attorney is what I really wanted to talk about today. Hopefully that made sense. If it did, that's great. If you have more questions about this, or if you want to talk about anything else related to estate planning or probate, you can talk with us over the phone for free by going to cmslawfirm.com. All right, as always, I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.